You're listening to the Valley Current.
Welcome into the Valley Current. We're doing a little special edition here with Professor Michael Risch because of a ruling that occurred this morning by the U.S. Supreme Court. I guess they're working through July. They usually wrap up in June, but they decided the Booking.com case, which Mike and I did a part one on, and we're not too surprised by the outcome, right?
Yeah, 8-1 was a little bit of a surprise, but otherwise not surprising. Yeah,
let me just give the background, because there was a part one that we did that set the stage for what was an important argument that was made in the Supreme Court on C-SPAN, which I think we both listened to that morning, or at least I know I did, and I think you eventually listened to the recording. And the advocacy was interesting because there were different levels of two female advocates, one of which had the case for Booking.com, and I thought she did a great job, and she's been interviewed about it. And one of which was for the Trademark Office, or maybe the Solicitor General. Do you remember who argued the case?
Well, it was a solicitor, but arguing on behalf of the government.
Right. And in that case, the government's argument, as I recall it, was very much, hey, look, a domain name that's generic like Booking, the fact that it adds .com doesn't really change matters. It's still generic. We're not going to register it, period, full stop. And the argument of the owner of the domain name, Booking.com, was, wait a minute, we are so well known and we are such a trademark around the world. It may not be the strongest trademark around the world, but it still is a trademark, and it should get registered. And that case made its way to the U.S. Supreme Court on an 8-1 decision that issued today. And you said the only thing that surprised you was 8-1. You thought it would be a bigger split based on kind of the personalities of the court?
No, I just didn't know. So I figured Booking.com was going to win. I just didn't know what the division would be.
Yeah, why were you so certain, Mike? I kind of thought it was a closer case, except when I heard the oral argument, I frankly thought the lawyer for Booking.com did a much better job than the lawyer for the government. But, you know, styles change and different people are doing different things. It was one of the first cases to be done by phone this year because of COVID-19.
I thought the tenor of the questions made it clear that Booking.com had the upper hand. The judges weren't particularly worried about the monopoly. You know, you get Booking.com, now you can lock out everybody with Booking. And once that went away, there's no real bar to getting Booking.com, because that's the only real concern with giving somebody a trademark in Booking.com, is that they're going to stop anybody who wants to use the word booking. When the judges said, we're not worried about that, then, you know, basically the ship sailed.
Yeah, the ship sailed. And I think that a lawyer for Booking.com made an interesting concession along the lines of, look, if somebody puts a couple of words in front of or behind Booking and uses it in a generic or descriptive way, so long as it's not unfair competition, there's not much that Booking.com can do about that. In other words, it's kind of a thin trademark, and exact copying will certainly be chargeable with infringement, but derivatives, as it were, we'll see if they stick to that view, but at least that was her view in the oral argument, that derivatives, so long as not intentionally misleading, were available. So I guess you could have a South Carolina Booking.com maybe, and a Philadelphia Booking.com, and maybe a New York Booking.com.
Unlikely, right? I mean, unless people start saying Booking.com without actually having the .com domain name. So that's the part that's a little bit strange, right? So if you accept that it's going to be a narrow mark, then what do you need the registration for? Because nobody else is going to get Booking.com as a domain name, and nobody's going to advertise using Booking.com, because that'll only help Booking.com, because everybody would go to the website. So there'd have to be some very particular type of counterfeiting injury associated with this. And when it's a pure services website, I don't know what that is. I can see that for counterfeited goods site like 1-800-contacts.com or glasses.com, if people are selling glasses that say glasses.com, but they're not really from that website, then you've got a counterfeit issue. But it's not like people are selling booking.com products.
So when you think of this, do you think booking.com just went out of its way to spend a bunch of money on sort of arguing a case that really didn't matter in the big picture to its business? Because I note, and we might want to put it up on the screen, that booking.com, when you go to booking.com, and I'll put it up on the screen just so people can see it, it doesn't actually give you a little TM after booking.com. It's almost like they kind of use it in a generic way. Yes, it's in white versus blue for the .com, and maybe they're trying to draw some distinction there. It doesn't even have a little TM. They'd obviously like to have the R with the circle. Legally, they can't have the R with the circle without it being actually registered. It's a very simple website in the sense that you look for, it's like almost a Google type of fill in a couple of pieces of information and we're off to the races. For example, if I wanted to visit you and I put in Villanova, I don't know if it's going to come up and say, but yeah, Villanova University, sure enough, it says, if I want to go to Villanova University for July 4th, let's call it July 3rd, with a checkout on July 7th, it'll just do a simple search. I'm sure you've probably done this before and seen this before. And it says there's two properties. You might say, yeah, those are not even open right now. But one is the Marriott Philadelphia West. Oops.
It's funny they call it Philadelphia West. It's 20 miles out of Philadelphia.
Yeah. So, it sort of does this on almost a worldwide basis. So I wonder whether there was an international aspect to this, right? And it gives ratings and feedback and lots of other stuff. That's the way it works.
There could be, but what are they going to go after booking.es in Spain? I don't think they can do that, right? Because once it's registered as booking, somebody else registers it. I don't think the trademark right helps you. It could be that the registered trademark helps you with domain name arbitration, having the registered trademarks good evidence against squatters.
Yes.
Wanting to get booking.ch in Czech Republic or booking.es in Spain, and you want to say they're squatting because they don't actually have something. Having the booking.com trademark might help you take those domains. Maybe that's what it's all about.
You're saying it may be a way to clear out in terms of the World Intellectual Property Organization or the WIPO type arbitrations, a way to say to basically the world of arbitrators, hey, we won this case, we've got a registration, that gives us a presumptive right to clear out people that are essentially doing various domain squatting, right?
Right, if they don't actually have a real business.
So it's kind of, you would argue it's kind of a way for them to get ready for other fights that maybe they're already in. The case was by Ginsburg. She delivered the opinion for the court. And Breyer, who had lots of questions, I remember, almost about competition, did a dissenting opinion. Were you just surprised by Breyer's dissent at all?
Not one bit.
Because you heard it in his questions, right? His questions were like, I don't understand how you can monopolize a term that is really a generic term. The word booking on its own, leave out the .com, is the generic term for booking a hotel. That's just the way it works.
So Dennis Crouch on his Patently.io blog likened this to Breyer's patentable subject matter jurisprudence. Generic on its own, booking is generic, .com is generic. You put them together, you can't trademark it.
Right.
Just like with patent, you take two things that are kind of abstract, you put them together, it's still abstract.
Except I always give the counterexample, and clients light up when I say it. Take the word general, take the word motors, and put them together. General Motors is no longer a generic term, even though general is generic and motors is generic, but put them together as General Motors, and you've got a potential trademark that has huge secondary meaning, right?
Yeah, Breyer's not seeing it that way.
Well, Breyer opens up as, what is booking.com? To answer this question, one need only consult the term itself, an online booking service. The company's name informs the consumer of the basic nature of its business and nothing more. Therein lies the root of my disagreement with the majority. nice opening paragraph, well written, kind of makes the point and makes the point pretty quickly. Of course, he then goes on for like 9 or 10 pages to review the history of the law of trademarks. It seems like he could have stopped right there, right?
Well, I mean, the history is a big, I mean, the real disagreement, we talked about this in the last one, is whether .com is the same as Inc. or company. The court was invited to overrule that old precedent that said, Inc. and company are basically words we can just ignore, but the court didn't do that. Instead, it said because .com is unique, there's only one booking.com, it's not the same as Inc. and company, where you can have many with the same name.
Right. So let me ask you, when you see a long dissent like this, the first thing I think of is he may have thought that he was actually going to get a majority, and he circulated this opinion with a view that it would be the majority opinion, and he just couldn't rally the forces to get 4 other people behind him, right?
I don't think so with an 8-1.
No? So you view it...
You could have a 5-4.
You view it as Ginsburg pretty much had the lead assignment to write the majority, and she couldn't convince Breyer, and it just wasn't worth trying to convince him anymore.
I think so. I think so. I mean, Breyer's the senior judge, so, well, I guess Roberts was in the majority.
Right. Roberts gets to declare. I think Roberts gets to declare, and the only question is whether or not Breyer said, I want to take the first draft and convince you guys before anything gets
I doubt it. I doubt it. I think they voted right away. This was how it's going to go, and he just wanted to make the best case.
So you're saying, in part, you agree, maybe in full, you agree with Professor Crouch, that he's consistent on the view that anti-competitive principles or competitive principles should trump a lot of IP, and this is just another example, right?
Who, Justice Breyer?
Yeah, Breyer.
Yeah, I mean, he's very concerned with IP. I mean, in my mind, there's 2 types of... there are multiple ways, but there are 2 ways to look at how you limit IP. The first is we're worried about competitive principles, and therefore we're not going to grant the right. And the second is we're worried about competitive principles, so when we grant the right, we need to consider really hard about how that right is enforced.
Right.
Breyer tends to fall into the we are not going to grant the right camp.
Right.
Ginsburg is a little of both, depending on what the IP is. And others tend to be more, we're going to grant the right and we'll let it sort it out. Now there are things that fall out of that, because if you don't grant the right, you avoid costly litigation, but you also may wind up allowing more what would have been infringement.
So do you think the court, this decision indirectly might signal that the court is going to take a second look at things like the Alice decision? Do you think there's a possibility of that? Do you see any connection at all? Because I think jurisprudentially, they treat IP like just one bowl of soup. It's just a different mixture of vegetables. I don't think they view it as copyrights and trademarks and patents are somehow jurisprudentially separate the way we do.
They've had really good opportunities. They had a case this term where literally everybody told them this is the case to take. The Federal Circuit said this is the case we need you to decide. The Solicitor General said this is the case we need you to decide about medical diagnostics, and the court didn't take it.
So you're saying there's not really overlap here. This is pretty much specific to the Lanham Act and specific to a trademark office policy, because they have consistently struck down trademark office policies. Like the last one I could think of was the policy dealing with kind of X-rated words, right? Like the F-U-C-H-T, like the
F-U-C-T.
Huh?
F-U-C-T.
F-U-C-T. They said that can be registered, even though there was a long-standing PTO rule that things that are embarrassing or X-rated are not to be registered, right?
It wasn't even a PTO rule. It was in the Lanham Act.
Right. So they took a constitutional view on this. This is sort of a strict, what I would say more of like a statutory interpretation case, right?
I think so. And you can as Professor Crouch did with the subject matter thing, come up with ways that are overarching views of the court, but sometimes it's hard.
Right.
This is a little bit hard.
So was there anything in the majority opinion that, I mean, what I contrast is I always look at the first paragraph of the majority versus the first paragraph of the dissent. And I actually think the better written first paragraph is the first paragraph of the dissent in terms of communicating in very few words the essence of the dissent. If you look at what Ginsburg does, and I'll put it on the screen for a second, it's sort of a roundabout way of kind of getting to the point. I'll just put it on the screen for a second, just so we look at it together, because this is how I read opinions. I start with the first page of the majority and then the first page of the dissent, and then I try to get my arms around kind of where are they going with this. She says, this case concerns eligibility for federal trademark registration. Okay, I mean, not a too exciting opening remark. RespondentBooking.com, an enterprise that maintains a travel reservation website, not a booking website, by the same name, sought to register the mark Booking.com, concluding that Booking.com is generic for online hotel reservation services. It's more than hotels. I think it's also airplanes and a bunch of other stuff. The U.S. Patent and Trademark Office refused registration. And then she goes into a generic name, da-da-da-da. It seems like it's kind of a long-winded, roundabout way of kind of getting to the point of we reject the PTO's sweeping rule, right?
Yeah, but it's a little bit unfair to read it that way because she has to introduce the case, what it's about, et cetera. Justice Breyer has the benefit of people knowing what the case is about by the time you get to his first paragraph.
Yeah.
And so he can assume knowledge of what these issues are when he says what the problem is.
Okay.
That said, I agree that you could do a first paragraph that more quickly got to the point and then went into it. Judge Easterbrook on the Seventh Circuit is really terrific at those first paragraphs.
Right. I mean, to me, people either get turned on or turned off by the way a first paragraph in a brief, a first paragraph in an opinion, a first paragraph in a letter, even a first paragraph or a sentence in an email makes a difference on whether you're going to capture the audience and keep them, glued to whatever you're going to write here for like another 20 or so pages, right? In the majority.
The majority's not that long.
I think it's about 20 pages, Mike. Hold on a second. I'll give you the exact answer. She does deal with the dissent at one point. Let's just go to the bottom.
Well, It's interesting. It stops there. It stops at 16, and then you got the syllabus. The majority's short. The majority's like 12 pages.
Okay. There is a concurrence by Sotomayor saying, and we haven't focused on that, but we might as well do it. The question before the court here is simple: whether there is a nearly per se rule against trademark protection for a generic .com term, kind of doing the work in both talking about generic and .com. I agree with the court that there is no such rule, a holding that accords with how the USPTO has treated such terms in the past. I had two observations. She gives some credit to the dissent, and then she says something about the PTO. She might be kind of a mediator of some sort here in a sense. I don't know. Maybe she just threw this in. No one else joined her. And then it goes to Breyer and the dissent about what is Booking.com. One need only consult the term itself, right?
Right.
There it is. So let me ask you something. We have computerlaw.com for the last 35 plus years. We did attempt to register it, and this nutty per se rule applied, and we were denied registration, even though we've used it consistently. What's your view on whether computerlaw.com should be registrable now?
I think the same thing applies, which is I think it's totally registrable, and the question is, what are you going to do with it once it is?
Well, what you do with it is you try to deal with people that are trying to take advantage of related domain names that you're not paying for. If someone grabs computerlaw.net, I think, though, we have it. I mean, there's a lot of subdomains that complicate things, right? Because there's computerlaw.club out there and computerlaw.xxx. I mean, There's all kinds of stuff. No, I'm serious, Mike. I'm not making this up.
I know, it's just very funny.
I mean, every time they introduce a subdomain, it opens up all sorts of issues. And I don't know if you ever see some of these bills we get for all the domain names that we have to store to prevent squatters from redirecting traffic, right?
That's right. That's right. But the question is, does the registration for the .com mean you automatically get it? The problem is, what if somebody's got computerlaw.biz and it's a valid domain name to some other law firm? Then what do you do?
Well,
who's entitled to computerlaw.xxx?
Yeah, I mean, there's a question of priority and there's a question of likelihood of confusion, right? Regardless. I mean, the other question that's in the background is, can Booking.com ever become a famous mark by dint of the registration existing for a long enough period and people saying, hey, it's famous?
It can't. Well, it may be famous already, but the question is, what's the dilution, right? It can't just be Booking. In the same way that computerlaw.com, the likelihood of confusion can't be just the computer law. The .com's got to be part of that. The problem is, if you're going to argue that .com means something in order to get your trademark, then you're stuck with .com meaning something. So if somebody uses something else and you're saying, look, the .com is what makes us unique and non-generic, it really limits your ability to go after other people. So I posit maybe you can go after the cyber squatters who aren't doing anything. But if somebody's got a legitimate business that is using a .biz or a .info or whatever, it's unclear to me. And this has been the problem with the domain name disputes all along, which is when you've got multiple people with multiple different domain names, it's unclear why one person should get it. This was an argument made in like one of the very first arbitrations for Madonna.com, because Madonna, the singer was arbitrating to get it back. And the owner of the domain name was like, well, why should you get it? Why shouldn't Madonna Hospital get it? Why shouldn't they get Madonna.com? Why do you get it simply because you were the first one to sue?
Right. Well, this might be an area where the law on the books is a little different than the law on the streets. We talk about that sometimes, which is the law on the books and the beauty of Supreme Court rulings. The way they translate at the district court level and oftentimes even at the appellate court level is if there looks like there's somebody with a black hat and you've got a registration, that district court is going to look very carefully at the value of the argument you're making, because you took serious registering your mark, paying the fee, right, keeping it going. And it's a little bit like getting a patent, which is you went to the work of getting a patent, it's presumptively valid, clear and convincing evidence supposedly is required to knock it down. And if you sue, if a federal court is supposed to give you a chance to have a trial. Now, we all know there's a million hurdles to get there on a patent. There aren't a million hurdles in a trademark case. A trademark case tends to be much more straightforward. You have a registration, someone has come close enough to cause likelihood of confusion, you've got some evidence, maybe evidence of actual confusion. I mean, look, I'm wearing the computerlaw.com t-shirt or sweatshirt. Nice. We did get the registration of Lawyers for the Digital Economy. We like to say Computer Law represents the firm that has lawyers for the digital economy, right? That's what we do. And in theory, if there are other people that say, I'm computerlaw.biz and we are the lawyers for the advanced digital economy, that sounds or feels like sort of passing off or deception designed to take advantage of 35 years of being in practice. In fact, I've got here my 40-year plaque of being in practice in California. So it's kind of a special place to be. You'll get there someday, young man.
One day.
So, Mike, any other follow-up remarks here? Just another couple of minutes and we'll wrap up.
No, I wrote a blog post on Written Description blog detailing this. The one source of confusion I talked about there was we used to get email that was being sent to computerlaw.com.au, which was an Australian computerlaw.com.
Right.
And I don't know what you do with that. I think there's probably nothing you can do with that.
Well, if you don't have a practice in Australia and you're not licensed in Australia, and that's a pretty separate market, But I have to
Right.
tell you, there's actually a lot of litigation funders now in Australia doing computer industry cases. And I've had some confusing inquiries from those Australian lenders, litigation lenders, asking, are you doing these cases? Are you interested? So it has become a global internet-based economy. And there will be more and more companies like Booking.com seeking to protect the uniqueness of their domain name, and then trying to carve out as much halo value as they can around that in the way in which they apply it. We'll see whether the remarks that counsel made that, hey, they can't stop many people who are doing different things, whether that's what they actually put into practice. We'll see whether new cases get filed both in the WIPO, sort of arbitration sense, as well as in the district courts, because obviously having a registered mark, which they're going to get now, presumably it'll be processed, presumably ours will be processed too, results in a ticket to a federal trademark case if you want to bring it under the Lanham Act.
Yep.
Right? Well, thanks for your time, Mike. Give me the link to your blog post, and we'll link it to the podcast so that you get some additional traffic from it. And
all right, I'll send the link.
Good. Take care. I hope all is well back in Philadelphia.
Thanks. You too.
Is school opening up in session, or are you going to play out the whole video presentation?
No, we're in the summer, but we're opening live. We're planning to open live in August. About 20% of our classes will be online.
20% online, and the rest will be actually in the classroom, but spaced 6 feet apart?
Yep.
Really? So the classrooms are getting much bigger or much smaller, one way or the other, right?
Yeah. I mean, it is causing. We had to redo our whole schedule, but we're lucky we have a new building, and so whereas a lot of my colleagues are saying that when they have to go to 6 feet, they're going down to 25% capacity. We're only to half, so we've got rooms that'll hold 70 people even at.
So you're okay even with the 6 foot apart view? Right.
We have to have we had to split a couple of our really big classes into two, but other than that, it's been fine.
Are you going to have masks on, or masks for the students?
Everybody wears masks.
They already do, right?
Well, nobody's in the building now, but
when they come to the building, will they be wearing masks?
Masks are going to be required inside.
Oh, requirement. So I had one other question I knew I wanted to ask you, and it just didn't dawn on me, but let me ask you just to close up. Do you think this opinion at all might influence the outcome in the Google Oracle case that's still pending? Zero.
I don't think so.
Not even with Breyer kind of signaling kind of how he feels about competition, because to me that's a Breyer trademark. That's Breyer's own trademark. Remember, Breyer is the older brother to Judge Breyer, who's on the district court here in San Francisco.
Justice Ginsburg is going to vote in favor of protection, probably, and Justice Breyer is going to vote against protection, probably.
Okay.
My amicus brief was targeted at the Justice Ginsburgs of the world to say APIs can be copyrightable, but when you make a compatible compiler, it's not an infringement. That's the only way you're going to get Justice Ginsburg on board, and even that, it's like long odds. But that's the way she's got to see the case in order to even think about going in favor.
You've just staked out 2 of the 9. Where do you come out on the rest?
I don't have strong views.
I mean, if Roberts is in the middle,
they're not. The copyright views are not terribly clear. Justice Gorsuch wrote a really good copyright opinion in the 10th Circuit. It limits protectability, but it's a slightly different issue than this one. We cited his case in our virtual reality treatise.
Right. Remind me of his 10th Circuit case. What was the name?
That was the Meshworks case with the lines of the Volkswagen Bug, and he ruled that the line art of the Volkswagen Bug was not copyrightable, originally distinct from the bug itself.
Okay. So really we're dealing with idea versus expression, and some people like to think that principle can be extended in a way to generic terms like booking.com versus, merely descriptive terms or what might be viewed as suggestive terms. And there's some sort of analogy between idea versus expression and generic versus arbitrary trademarks. Now, that's just a rough spectrum comparison. And obviously, you see many versions of snowflakes. I think at the Supreme Court, they just see wet, frozen water.
But it's all in the framing, because booking is an idea, .com is an idea, but booking.com is expression.
Right.
And so
like
the
General
question
Motors.
is, do you frame it as a combination of ideas, or do you frame it as something that becomes expression when put together? Does Oracle get a copyright in its APIs, or do you frame it as, is Google allowed to make a compatible compiler? Those are two different questions, and how you approach it will affect what your outcome is going to be.
But there is an analogy in the sense that the domain name does work as well, meaning the domain name is actually an address. It's an actual physical address, like an 800 number, right?
Well, some people see it that way.
Right. But I'm saying when you have this aspect of it's doing work as well, like it acts.
Yeah, but people will say the idea of these APIs are doing work, right? Oracle had a choice of many different APIs. They pick particular names.
Right.
So even then, it's all about the framing, about what's doing the work and why it's important.
Right, but choosing the frame is like choosing the policy. And if you want a policy that says we want competition, you choose the frame, as Breyer just did in his dissent. And if you want a policy that's more leaning towards strong IP, then you choose something else. And if you want something in the middle, you choose something in the middle, as I think your amicus brief very ably did.
Well, yeah, but not necessarily, right? You could, for example, choose competition and go with Justice Ginsburg and say you are allowed to have booking.com, but it's very narrow, so all you can go after are exact copies, right? So that's so ironically, that's the Justice Ginsburg, that view applied to Oracle would be you're allowed to have a copyright, and if somebody exactly copies Java, then they are infringing. But if they change it a little bit, then they are not.
Or if they change it a lot, they're not. I mean, it depends on what's a little, what's a lot.
It's a thin copyright, just like it's a thin trademark.
Right, and I think there is something jurisprudentially overlapping, and this is where I was signaling to you, and you said, no, I don't think it's true. I think there's a signal here on where the Google Oracle case, and maybe even where, what is it, Berkheimer? What's the case that's up there now? The 101 case, isn't there a 101 case that's up there now that's challenging the Alice decision? I thought there was one, right?
Oh, they denied cert.
Oh, they denied cert on Berkheimer?
Yeah.
Okay. So I think eventually, though, we're going to see some versions of this. Now, maybe they're versions that Breyer loses over and over again. I don't know.
Well, but that was my point. Justice Ginsburg is not going to make the thin copyright argument, although maybe she will.
Right.
It would be nice. That would be the consistent view.
Right.
But I don't hold out hope that we're going to get that consistent view from the same justice.
Right. What is
maybe we'll get it from a different justice.
Right. What is just to wrap up, what's the expected date on that oral argument? That's supposed to have happened. I
think it's going to be early in the next term.
Right.
So it may well be in October.
So if it's October and COVID happens or continues, then it'll be on the phone and available on C-SPAN. And just for listeners,
that'd be great.
If you want to listen to oral arguments, as I do and Professor Risch does, and then we talk about them, it is the best thing in the world for a young law student or even a young graduate to listen to either very good or very bad, often both, advocacy in the U.S. Supreme Court, even sometimes in the same case, where you get the sense for what it means to have a conversation with these justices on how policy should be set in the Supreme Court in different topics, in different cases.
So the audio is available on the Oye project.
Yes. And C-SPAN,
although it's not live on the Oye.
C-SPAN is live, and there are people that live blog as the argument is unfurling. So it's quite an interesting thing to watch. And of course, if you participate in it, you really get a thrill watching how people react to what your comments are about what's going on.
There's also a great audio collection called May It Please the Court, which is audio of some of the great oral arguments throughout.
Right, which we should
history.
mention that
I listened
gentleman,
to that. It was
that
fabulous.
professor was challenged with violating an ethical rule in the U.S. Supreme Court by smuggling those tapes out. And he just took the view that the First Amendment required their freedom. And ultimately, they did not sanction him. I think it was Ralph Fine, right? Wasn't that the professor, Ralph Fine, who smuggled him out?
I don't know the story. All I know is that it's a great collection of audio.
Right. No, there's a story behind that, and I'll find it and put it in the episode notes as with your link to your blog. So thanks for a little bit of time from your evening. I know you're 3 hours later. I'll look forward to reading your blog post and incorporating it. And thanks for the update on this case, because it really is part 2 of what we started as part 1, and I'm glad we were able to finish it.
All right. Thank you.
Thanks, Mike. See you later. Take care. Bye-bye.
Tune in next time on The Valley Current.